Hello, welcome to Legal Awareness web series. We have a very special and distinguished guest today, His Lordship Honorable Justice V Gopal Gowda ji, who was a judge of Karnataka High Court, then served as Chief Justice of Odisha High Court, and he was very popular in Orissa. At that point of time, I was working as the Vice Chancellor of National Law University, Cuttack, and it was due to his lordship's mentoring and support that we got a big funding from the state government. So if today you have a state-of-art, huge infrastructure in Cuttack, the foundation of that infrastructure was very much laid by Justice Gowda. Then he went to Supreme Court and has delivered number of historic and landmark judgments. As Chief Justice in Odisha High Court, I fondly remember the judgment in the Vedanta case was delivered by him, and he cancelled the land which was given to Vedanta. Then in Supreme Court also the famous Singrur land acquisition case came before him, which again he quashed. Some 1,000 acres of land was given to Tata Nano by the left government in 2006. Number of other leading judgments have been given by his lordship. At his farewell from the Supreme Court, the bar and the judges, they recalled his contribution. The Chief Justice of India, Justice Thakur, said he is a judge with a big heart. He was known as a people's judge, a judge who is committed to the cause of poor. He himself, in his farewell speech, said that Supreme Court is not meant for the haves. Even the haves not must come to the Supreme Court. And he also said that if Supreme Court does not protect haves not, then there is no hope in the country. Sir, we welcome you to Legal Awareness web series. It is our initiative. We now have 3,93,000 subscribers to this Legal Awareness web series. We have 204 videos, and we have been viewed 1.5 billion times. So 1 crore 50 lakh times we have been viewed. I welcome you to today's conversation with His Lordship. We are largely going to discuss the recent labor law amendments. But first of all, I want to ask His Lordship, why as a lawyer he felt more interested in taking up causes of labor. He would have picked up any other lucrative field, but why he decided to take so many cases of trade unions and other laborers.
Thank you, Faizan Mustafa ji. We are proud of you. You are doing great human service in the country for the countrymen, and on a very important, relevant topic, you are very boldly, courageously talking, speaking out, making the people to understand and function in accordance with the Constitution of India. You have given me a great opportunity to have my say to all your viewers in the entire country. A very, very important topic on which you have requested me to speak. Now, you have asked me why I have chosen to appear for the working class. Throughout my career as a lawyer, from 1975 to 97, up till I was elevated to the High Court of Karnataka, I only accepted the brief of the workman. I never appeared on behalf of the management. My commitment to the weaker section of the society, I consider that workers and laborers of this great country are the weaker sections of the society. That is what is said by the Supreme Court in the Constitution, preamble of the Constitution, the weaker section of the people, working class, must be rendered social justice. So I thought my commitment to serve the poor people, I never thought I must make wealth out of my profession. I joined my senior, K. Subbarao, who was exclusively appearing for the workmen. But therefore, I thought I must render and get justice, which is envisaged under the preamble of the Constitution, and to see that workers will produce the wealth of this country for development and the growth and the progress of a country. Only a worker who are the equal partners, which is not recognized by the capitalists of this country and the entire world. Therefore, I thought I must give legal aid to them. I never thought it is only money that will satisfy me. The service which I rendered, and I got them back the job, the economic demands which were met by the employers by appearing on their behalf and defending them in the court, from labor courts, labor commissioner, conciliation officer, the high court and the Supreme Court. In that way, I must have given justice to lakhs and lakhs of people and millions of people, the public sector undertaking, private sector undertaking, and the unorganized sector. I used to appear. Large number of workmen were waiting near my office where I was a lawyer and in the court. In fact, more than 50% of the cases in labor courts, I used to appear as the workman. I used to ask my junior colleagues to defend them effectively. I used to defend them in the High Court. I used to defend them before the Labour Commissioner. I used to appear in all the fora. The greatest satisfaction, which would not have satisfied me if I had made the materialistic world. That's how I chosen this the labor field.
And
Apart from labor field, I used to appear number of farmers, the women organization. I used to appear for the central trade unions. I used to appear for the associations. I used to have a lot of the civil work, the constitutional matters, service matters, or land reforms matters. Apart from labor matters, I have done lot of good work to the public litigant during my tenure as a lawyer for 22 years.
yes, sir. And sir, in most of these cases, I am told that you appeared pro bono, you never charged them. So, sir, do you recall one or two very significant cases in which you appeared as a lawyer?
One case, two, three cases I can tell you. A very pathetic case. Gabriel is a worker dismissed from service. He is a Tamilian. He was working in the Binny Mills. His application serial number 6 of 1981, 33 to be application filed by the management of Binny Mills. He used to walk from the Binny township to the labor courts. He had no money to eat. His family was starving. At that point of time, I used to appear for him. I used to defend his case. I used to give money to him to have something to eat and go back to his house. In fact, that man, I succeeded in the case. He got job and he got money. Like that, one more important case, HMT employee, he was a BA graduate working in the HMT case, HMT factory. He was dismissed. Some other lawyer asked me, he's a very incorrigible fellow, please take this case and defend him. I defended him. He became mad. He was sleeping on the railway platform. I used to counsel him. I told him, conduct yourself as a decent man. I used to tell them, if you have got only one pair of cloth, wash them, have a nice the bath, come to my office. All my office colleagues were dead against me, accepting his case. But I settled that matter. A very frivolous charge and a fabricated charge on which the misconduct, he was dismissed. I felt for him and I got him some 25,000 rupees out of settlement because he was not in a position to sustain, to defend the litigation up to the Supreme Court.
Sir,
There are so many, thousands I can tell for want of time. I
Yes, we have to
limit
finish the
myself.
interview in 20-25 minutes. But we will bother you again, sir. Sir,
No.
since you are also interested in constitutional law, please tell us, sir, briefly how Constitution of India deals with the rights of the labor.
Uh, Up to 1980 and 1990, the jurisprudence, industrial jurisprudence interpretation was something different. Even during 1960s, the interpretation of industrial law is totally different. After 1990, new economic policies were implemented. The capitalists and the government felt that the labor laws and labor law interpretation is in favor of the workman. No capitalist will come and invest their money and provide job. That has been proved to be wrong. The up to 1980, during the period of Justice Krishnaiah, Justice Chinnapareddy, Desai, and Thakkar, the interpretation of the two letter and the two object and intentment of the Industrial Disputes Act, keeping in view the industrial peace and harmony, is the main concern for the purpose of protecting the weaker sections of the society. The labor is an equal component with the capital, is their understanding. That is the interpretation of industrial law and all labor laws, nearly about 44 labor laws in the country. The judgments during that period is totally different. The constitutionalism and the directive principles policy have been interpreted during that era by the great judges of the Supreme Court, whose names I just now mentioned. Thereafterwards, the totally different attitude, and according to me, the rights which are where plenty, part 3 and part 4 both constitute the human rights. The Supreme Court view is totally different after 1990, and even the earlier law which has been laid down, they have overruled without considering the constitutional provisions, particularly the directive principles of the state policy, and it went against the working class, which has damaged the growth of this country, according to me.
Sir, what is your reaction to the plight of migrant workers? Lakhs and lakhs of them are on the road. And the Supreme Court of India, which is considered to be one of the most powerful courts in the world, and which some people said, some scholars after PIL, that it now takes the sufferings of the people seriously, but it did not initially hear the matter. And now we see that there are a number of positive judgments coming from various high courts. So as a former judge of the Supreme Court, how do you look at the whole question of this plight of migrant workers, and why Supreme Court did not do what many people expected it to do?
You have asked me very, very relevant, pertinent question to me. I have written an article today, which is published in the Deccan Herald, regarding the migrant workers and how the Supreme Court dealt with their grievances when the public interest litigation filed on their behalf by lawyer Prashant Bhushan, and another social activist. I am very sorry to make an observation at this point of time that the interpretation, not understanding the plight of millions of the migrant workers have been traveling to their respective native places, thinking that they can live and die in their native places. That a situation has arisen during the emergency, health emergency declared by the government of India, without giving reasonable time for these people. When lockdown was declared on 23rd March 2020, millions of people across the country who are working in various the sectors have become homeless. No work, no food, no shelter. They were not able to they proceed to the native places because transport facility was not there, and the respective state governments were also not allowing them to move. The state government, except Kerala state government and some other NGOs and Delhi and other places and voluntary organizations came forward, they offered them some the food. Now, at that point of time, they went and filed the public interest litigation. They are the workmen, they have got the rights under Part 3 and Part 4 of the Directive Principle State Policy. They are all unorganized sector, they are innocent, the vulnerable people of the country, they wanted some relief from the Constitutional Court. The Supreme Court of India has got a great reputation in the world over, and the judgments of the Supreme Court are being followed by Supreme Court of America, Supreme Court of Australia, and different parts of the world. In such a situation, it is the foremost duty, according to me, as a constitutional court, the governance of the people, including the migrant workers. It is the duty of the Supreme Court and Constitutional Court. When they knocked the doors of the Supreme Court, the situation was very precarious. The workmen were walking thousands of kilometers from Karnataka state to Guwahati, Bombay to Guwahati, West Bengal, Madhya Pradesh, Uttar Pradesh, and children you have seen, you are repeatedly showing in your website legal awareness. I saw that. Lakhs of people and millions of people watched it in the electronic media, print media. The people have become helpless. The children, the pregnant woman given a birth in the train, the people, 400, 500 people during the process of walking without there being a transport facility provided by the responsible government, central government and state government. The Supreme Court should have given direction to the central government. It is your duty during this pandemic emergency. You have to take care of them. They are all the working class, vulnerable section of the people. They are mainly responsible for production, building the buildings, apartments, production, textile production, engineering production, all whatnot, everything. The Supreme Court, in a very light-hearted manner, they dealt with. I am telling you with a great pain and agony that Supreme Court did not live up to the expectation, did not discharge their constitutional function, being a great apex court in the country to protect the human rights of the people of the country, particularly the vulnerable section of the people, the working class, particularly these migrant workers of millions of people, 11 crores of the migrant workers have been still struggling, still they are sleeping in the open field. They don't have the water to drink, they don't have the food, they don't have the clothing, they don't have the money. The corporations, state governments have taken different stand. Central government came forward, 85% and 15%, the state government must bear the expenditure of the transport facility. It was not implemented. They paid money and some of the people traveled. Still, all these people near the police stations, in the open fields, for waiting for their turn to go back to their places. Very, very sorry state of affairs. Supreme Court did not intervene. Whatever the central government Solicitor General made submission, it is blindly accepted without verifying and asking them to produce the record. When the record was asked to produce, Solicitor General, it is a sorry state of affairs. He says that these records cannot be made available before the court. Why? Bommai case, even the report of the governor in Bommai's case was made to be, is a public document produced before the court. What is this public secrecy of the document maintained by central government? This is accepted and dismissed, this requisition of this argued by Prashant Bhushan. Sorry state of affair. Supreme Court is required to protect the weaker sections of society. They are the producers of the wealth of this country.
Sir, initially the Solicitor General even said that there are no migrant workers on the road.
Before the apex court, Solicitor General making a wrong, false statement of fact in electronic media, in the print media. People are walking. You have shown their foot in your video. People have seen. Millions of people have witnessed it. Before the Supreme Court, Constitutional Court, Solicitor General, or with the court officer, goes and make a wrong, false statement of fact, which is accepted by the Supreme Court.
Sir,
Very sorry state of affairs.
yes, sir. Sir, number of state governments are coming up with ordinances suspending labor laws. Do you think that this is the right thing to do? Yesterday, International Labour Organization has also written to our Prime Minister, and ILO has been saying that no reforms in labor law should be done unless all the stakeholders, that is the labor, the industrialists and government, are on board. What is your reaction to, sir, these changes in labor law which are being proposed in UP, in Gujarat, in Madhya Pradesh and in some other states?
Even Karnataka state, they are proceeding to do it.
Yes.
According to me, all those ordinances promulgated at the instance of the respective state government's cabinet resolution are unconstitutional and ultra vires to the labor laws. Article 213 empowers the legislative power of the governors to promulgate an ordinance when the legislative assembly is not in session. The proviso to Article 213 clearly mandates if the laws are traceable to the concurrent list, all labor laws are listed in concurrent list 3 entries 22 to 24, particularly the Factories Act, Industrial Disputes Act, Trade Unions Act. The promulgate ordinance by the governor at the instance of the state government on the basis of the direction issued by the central government, without there being an instruction, the governor has no power constitutionally to promulgate an ordinance. Number one, this is, I have written an open letter. Number two, if the provisions of the central enactment, labor laws, particularly Industrial Disputes Act, Payment of Wages Act, Minimum Wages Act, Provident Fund Act, Trade Unions Act, these are all enactments which were made prior to the independence, prior to we became republic, prior to the constitution. Nonetheless, all these enactments, Supreme Court has ruled, they have passed the test of Article 13(2) of the Constitution of India. So therefore, they are all valid. Article 254, 1 and 2 of the Constitution of India specifically deals with if the state legislature is empowered to amend the central enactment, the amendment must be in conformity with the provisions of the central acts. If the central acts are if the state amendment or a promulgation of ordinance is contrary to the provisions of the central enactment, the parliament law must prevail, but not either the state law or the ordinance. The ordinance issued by Madhya Pradesh state government, Gujarat, Uttar Pradesh, and including the other attempts, Punjab, Rajasthan, all other states, according to me, are all unconstitutional because they run contrary to the provisions of the central enactments, Industrial Disputes Act, Trade Unions Act, Payment of Wages Act, Minimum Wages Act. This runs contrary to the constitutional judgments of the Supreme Court. Supreme Court has said even President cannot give assent. If assent is required to be given, which are the provisions or the ordinance provisions of the State Act or ordinance of the governor, conflict with the provisions of the Central Act, to that extent, if it is repugnant, it is the duty of either the governor office or the Law and Parliament Affairs Ministry to write a detailed reason why they are promulgating ordinance which runs contrary to the provisions of the Central Act. Then it is the duty of the President of India, according to judgment of the Supreme Court, right from 1959 till 2013, Supreme Court repeatedly said that President mechanically cannot nod and give assent to either the law that will be enacted by the state legislature. Then the provisions of, if the assent is given without satisfying, it is not mechanical, it is application of mind. If there no application of mind, then also merely because assent is given, still the law which is enacted by the parliament will be valid. That is the law of the land. That is the law laid down by the Supreme Court way back in 1959 by the Constitutional Bench, which has been reiterated subsequently. Therefore, ordinances are unconstitutional. Ordinances promulgated by the aforesaid states is contrary to the law declared by the Supreme Court, which is binding on them, and Article 141, blatant violation of all the provisions of the Constitution to Article 254, 213(1), and judgment of the Supreme Court, and violation of rule of law by these states who have taken the oath under the Constitution that will respect and will adhere to the provisions of the Constitution and the law.
Yes, sir. So,
what these people are doing.
Sir, that's why states have referred these matters to the central government, and therefore the ball is now in the central government's court. Let's see how they react to it. Sir, you have given a landmark judgment in Mackenzie's case, where
Yes.
laborers were terminated. Kindly, sir, tell us about your judgment in this case.
That is the case of retrenchment, no?
Yes.
There is a case of retrenchment from Bombay.
Retrenchment, yes.
Retrenchment. I had more than 130 employees, I think.
Yes.
Mackenzie's case, no?
Yes, sir.
Mackenzie's case, I have said that blatant violation of 25F, the permission not obtained, and permission must be in writing from the government before retrenchment. I have followed the earlier bench judgment. I said that the workmen who have been retrenched, which is a malified intention, there was no need of retrenching en masse the people. This was about 6 years back. I have forgotten the facts of the case. In sum and substance, I have interpreted section 25F and the provision where permission is required, because the state government has to examine the bona fide action on the part of the employer, whether they can be retrenched or not. The retrenchment is bona fide or not.
Sir, in this judgment you had said that this termination of employees is in violation of Chapter 5A and 5B of Industrial Dispute Act, and it is void ab initio in law and ineffective, and it suffers from nullity. Now, in the recent labor law reforms, these provisions are to be suspended, and hire and fire policy will become widespread. So, do you think that all the struggle of the workers in getting these laws passed will come to an end, and one fine morning through an executive order these laws will get suspended if the central government gives their concurrence to it?
That is the effort of the central government and the state government at the instance of the capitalists and the employers. That will be, according to me, will be counterproductive. And if the central government, in blatant violation of the ILO, if they make an effort to concur with the state government's views to nullify Chapter 5 and 5A and 5B of the Industrial Disputes Act, I can tell you that will be contrary to the judgments of the Supreme Court, Constitutional Bench judgment Supreme Court. The Supreme Court repeatedly has held for retrenchment the mandatory provisions provided under Chapter 5A and 5B of the Industrial Disputes Act shall be strictly adhered to, otherwise the action of the employer will be nullity. If the central government is for the people of this country to govern the people, particularly keeping in view the preamble of the Constitution, justice is the basic structure of the Constitution, justice, social, economic and political, they must understand the capital alone cannot give production in any country for that matter, even either a primitive society or a imperialist country. They must keep in mind, if they take law into their hands, ignoring the rule of law and the binding principles of the Supreme Court, and they suspend the provisions of 5A and 5B, when particularly the code, four codes, after abolishing, repealing 44 laws, four codes they have codified, the parliament they have passed, it is pending before the Rajya Sabha without awaiting the approval of the Rajya Sabha. The laws, 44 laws, particularly Industrial Disputes Act, Factories Act, Trade Unions Act are in vogue. If they make an effort to take away the rights of the workman, I can tell you that this country will face the wrath of the workman. That will be greatest disaster for the country. If we are facing greatest crisis of economy, I mean the pandemic, the emergency, that will be coupled with the people will die, starve, and it amounts to forcing the labor, which is prohibited under Article 23 of the Constitution of India. Blatant violation of the constitutional provision, blatant violation of the basic structure of the Constitution. If you make an effort to hire and fire policy by suspending Chapter 5 and 5B and other labor laws, allied labor laws, I'll tell you there will be blatant violation of rule of law. I appeal to the Supreme Court. Supreme Court must exercise its constitutional power and protect this nation, not the workman. Protect the nation. If you don't protect the nation, workman, the nation will destroy. The nation will be destroyed. Apart from that, you must understand the justice, social, economic and political justice to the weaker section. Apart from that, Article 41, 41, 42, 43, 43A of the directive principles, all these are safeguards to the workman, and safeguard to the workman means the safeguard to the nation and governance under the Constitution. They must remember this.
Sir, yesterday UP government also took the decision that the workers from UP cannot be recruited by any other state without the permission of the state government. How do you look at this proposal as a jurist and as an eminent judge and as somebody who is interested in the cause of the poor and the laborers?
I hope that the Chief Minister of Uttar Pradesh understands the democracy, understands Democratic Republic India, understands there is a constitution in this country. He must understand the people are sovereign. He must understand it. If he does not understand it, people will teach him what kind of obnoxious the government orders he is issuing. Who is he? He is there. Sovereignty is given by the people of Uttar Pradesh in the mandate, in the election, legislative assembly election, to govern the people. He doesn't understand the constitutional principles. He does not understand the constitutional democracy. He does not understand the human rights of the people of this country. He does not. Does he think that because he is the chief minister, he is a whole and soul and he can dictate terms? Who is he? He is after all a chief minister. Chief minister is elected by the people representative of that legislative assembly. The people representative assembly has given mandate to govern the people in accordance with law by constituting a government which must function responsibly. And this kind of obnoxious thinking and law has to be overthrown for a minute, for a second in the Supreme Court.
Sir, his argument is that he is making this prior permission mandatory to protect the interest of workers of UP. He is saying that his government will see that the states, other states which recruit people from UP give a good deal to the workers from UP.
Correct. The people are the citizens of this country. In Maneka Gandhi's case, 7-judge bench Supreme Court, with regard to impounding of the passport of Maneka during the Janata Party regime, Supreme Court has dealt with Article 19, 19(1)(a). The citizen, including the workman, entitled to travel not only any part of the country, any part of the world. Who is he to prevent? He is a monarch. He is a democratically elected chief minister. He must understand that Maneka Gandhi's 7-judge constitutional bench is binding on him. That's all. Yes. You must remember this. Law will prevail, but not his executive action.
Yes, sir. Sir, what is your idea about this 44 labor laws being converted into 4 labor codes? Do you think is it a good idea, or we should continue with all the 44 independent laws?
I gave a lecture immediately when the bill was prepared. I went into all the 4 codes in detail. This is again an effort at the instance of the employers in this country, forgetting the rights of the workman, the rights of the people of this country. The courts which are trying to enact repealing 44 laws, all these 44 laws, pre-constitutional law and pre-independence law, thereafterwards these all laws have been held to be constitutionally valid past the test of Article 13. Now, what is the fine? This is blatant violation of ILO resolution. In 1918, ILO has been come into existence. You are a party to the resolution.
We
are you going to?
India is
and
member.
Yes, Trade Union Act. Now you are telling trade more than 50% of the members of establishing a trade union must be of that industry. That is not the object of Trade Union Act 1926. Trade Union Act 26 is nearly about 94 years in vogue. This is on the basis of the Royal Commission report. After 1917, the revolution in Russia, USSR, all industrialists, all journalists, intellectuals thought that there must be industrial disputes in the Indian Trade Union Act. Indian Trade Union Act will function as a collective bargaining agent, is a person for the effective functioning and healthy maintaining the industrial peace and harmony. If a collective bargaining agent, it is not necessarily it is for the trade union for the employees. If a workman, employer and employer, they can have a trade union. They can function as a collective bargaining agent on behalf of the employers against another employer. Industry-wise, the trade union can be established. That's how national trade unions have come into existence. National trade unions, on account of the struggle, on account of their effort, on account of their sacrifice, today industries are collapsing today. That is because of the policies, wrong policies pursued contrary to the constitutional philosophy, and the wrong policies are pursued by the successive governments. They don't understand 44 laws. Industrial peace and harmony is most important in an industry for better and healthy functioning, good production, making profit, and give good wages, living wages to the employees. They are forgetting this. They are only one-way traffic. Tripartite meeting must be held. Tripartite means now, tomorrow, today. No labor department is required according to this the laws. No factory inspector, no checking, no license. All were permanent registration, and less than 50 people, no registration, no inspection, no Factories Act is applicable, no law is applicable. What kind of things are doing? You wanted unregulation. You should be regulated. If it should be regulated, if it is not regulated, you are not living in a feudal system. It will be a bonded labor. Can you go back?
Sir, thank you very much. It was pleasure having you. I can see the pain in your voice. You have spent many decades taking up the causes of the poor people, downtrodden people, workers. I can see that big heart which is feeling the pain of our migrant workers on road. Sir, we value your views, and we are really grateful to you for giving us that much of time. And I am, sir, requesting you that we will keep you bothering in Legal Awareness web series. It is very important that your views reach the larger audience. So thank you very much, sir, for giving us that much of time, sir. Thank
you. I'm sorry, I was little emotional because the ongoing events bothering me. That's why I am little anguished. I am little emotional. I am speaking. With good intention, I wanted to give my views on the topic. Thank you very much, Mr. Mustafa ji.
Thank
You
you.
are doing a great service. Long live. You will be a great resource person and a great intellect of this great country and a courageous person. I wanted person like you being a vice chancellor on all issues. You are coming with openness and telling the what is required to be told to the people and particularly people who are governing, either it is Supreme Court or the central government or the Prime Minister, the Chief Minister.
Thank
I respect you.
thank you.
I wish you all the best
Thank you,
in
sir.
your future endeavor.
Thank you
Thank
so
you.
Thank you, sir.
Thank you for giving me opportunity.
Yes, sir. Thank you so much, sir. This has been my experience of Indian Supreme Court as well as Indian government. When we really get frustrated by uh, our judiciary because of some of their orders or because of court not showing urgency in the matter, suddenly, some judges will rise up to the occasion and restore our confidence in the supremacy of rule of law and in the court as protector and guarantor of people's fundamental freedoms. I would say a similar thing about our government many a times as citizen, since we have very high expectations from our center and state governments. We think that they are not doing enough, and then we see that suddenly the governments really start delivering. As soon as my conversation with Justice Gowda was over today, a breaking news came from the Supreme Court. We also discussed in the interview, there have been articles in newspapers that the Supreme Court has not done enough in this crisis. Initially, the court did not hear the matter on priority. Then the court said that if labor is getting food, why they need money. Then the court said, what can we do if people are walking on the roads? And suddenly now, so moto on its own, a three-judge bench of Justice Ashok Bhushan, Justice S.K. Kaul, and Justice M.R. Shah took up the issue of various letters and the representations which have been sent to the Supreme Court about the continuing crisis of the stranded migrants on the migrant workers on the roads, on the highways, on the railways, and on the state borders. And it gives me immense pleasure and satisfaction that the three judges have shown utmost sensitivity and passed a very powerful order that adequate transport arrangement, food and shelter are to be immediately provided by the center and the state governments free of cost. We remember that there were very high charges charged by some of the state governments. We remember that Karnataka passed an order that we will not allow people to take trains. So it is satisfying. We were frustrated when initially the Supreme Court said that these many people are on roads because the fake news has created panic that lockdown will continue for 3 months. Now the court is in its own mold as a protector and guarantor of the fundamental rights, and has started taking the sufferings of the migrant workers very, very seriously, has heard the plight of these people, and has given another day after, asking government to tell Supreme Court what measures they are taking. Therefore, while in democracy, one may criticize government, one may criticize judgment, but at the same time, when the court or the government do something good, the objectivity demands that we appreciate the government and we appreciate our judges. If we can criticize our judges, wherever our judges deserve appreciation and commendation, they must be applauded. I really compliment Supreme Court, this three-judge bench of the Supreme Court, and I must thank them. I must express our gratitude to the Supreme Court. And this is exactly what Justice Gowda just said in this interview, that the Supreme Court of India should intervene in this matter. And as soon as interview was over, Supreme Court has heard the pain of a former judge of the Supreme Court. Thank you very much.